Thank you. Well, thanks a lot, everyone. And Dave, once again, thanks for bringing us all together, and thanks to APA. Much of what I'll be talking about, quite frankly, is a product of a lot of what I've learned over the last handful of years, in large part through participation with APA and getting to meet individuals, many of whom you've already heard from today, that have helped frame some of my thinking and some of the programs that we've implemented. I don't see John here. He was sitting here much of the time. He'll probably be back, but thanks to John and Quattrone Center. There he is. Thanks, John, for hosting us and bringing us together. Hey, well, so Multnomah County, you're thinking, where is that? Think Oregon, north part of Oregon. Portland is our largest city, the home of one of the greatest professional women's soccer teams in the world, the Portland Thorns. They finished second, unfortunately, this year to a pesky team. Who cares who that is? Now, our Portland Timbers are still in the hunt for a championship. That's our men's soccer side. I wish Dan Satterberg was still here because we just beat the Sounders in order to continue in the championship pursuit. Home of the Portland Trailblazers and home to my wife and where we raised our 3 children. And so we have a long, kind of rich connection to Portland in the Northwest. My office, just to give you a flavor of what Multnomah County looks like from a kind of a size standpoint, where I come from, 810,000 is our population of Multnomah County. The biggest concentration is that city of Portland. My office is made up of right about 200 full-time employees. Essentially 80 of them are going to be prosecuting attorneys, and then victim services, advocates, investigative services, and support. Oregon is a justice reinvestment initiative state. JRI came to Oregon, so to speak, in the 2012 area of time, where the governor at that time convened a work group. What followed then in the early part of 2013 was some robust conversations about what a piece of legislation would look like in the area of JRI, essentially in the, some people call it the Prison Reform or Justice Reform Bill. It was ultimately labeled House Bill 3194, and following a lot of work by a lot of people, it passed and became implemented into law in August of 2013. It was thought at one point, or I think for a very long time, that the Oregon District Attorneys Association, that's the prosecuting association of the 36 counties of Oregon, would never support House Bill 3194. It was believed that the Sheriff's Association and Chiefs of Police would never support a justice reform initiative in the state of Oregon. But I'll say that ultimately, at the time of voting relative to House Bill 3194, all 3 organizations were supporting House Bill 3194. So once passed, then began the hard work. And so that's a little bit of what we're going to be talking about, or maybe a lot of what we're going to talk about is what are the implications, what are the manifestations of a JRI model. So we're going to start with Treatment First program. And I'm going to call this the second generation of JRI initiative, at least in the state of Oregon. I'm doing this in reverse order because I want to spend a fair amount of time, or most of my time, talking about the Treatment First program. I think it's going to be drawing together many of the principles that we've been discussing today, using, say, risk assessment and where to properly place those in a continuum of evaluating certain circumstances and such. And then moving forward toward the end, the first generation of JRI, what we call the Multnomah County Justice Reinvestment Program, and I'll get more detailed as we go. So where did Multnomah County start relative to classic drug court programs? Well, we were, back in the early 90s, 1991, my predecessor, Mike Shrunk, the person who hired me and I worked for approximately a quarter century before I became the elected district attorney. I've been with the office since 1988 and took office from the district attorney standpoint in 2013. But back in the early 90s, Mike Shrunk was a visionary relative to the first iteration, if you will, of drug courts. He lost out. He was a second place finisher, if you will, to Janet Reno out of Miami-Dade, who rolled out the first formal drug treatment program in the country from a state prosecutor standpoint. I think Mr. Shrunk missed out by a month or 2, if I remember correctly. At the time, in the early 90s, it was a robust program, 500 to 600 people capacity, But over the course of years, it began a steady decline, and many, many variables contributed to that. Average duration of cases increased, funding began to diminish, and ultimately, I kind of tend to analogize this to it was a kind of the bones of a beautiful home, but over time need to be refurbished and need to be overhauled. The carpet needs to be changed, wall hangings need to be updated and such. And so we moved into an era where it was time to begin to look once again at what is our drug treatment court and what overhaul, what improvements do we need to make. So that process began in earnest. I put a bracket around 2013 and 16, and it deals with this concept of, as I talked about, JRI came to Oregon in that 2013 window of time, and this being the second generation of a product that sprung out of that, we began to look really hard at what is it that we're doing in the area of working with individuals struggling with abuse and addiction. We adopted two different programs, and I'm going to get at times pretty weedy, but very globally right now. We adopted two different programs, one called the Treatment First program. We're going to deep dive into that. And then I also went to Seattle a handful of different times, talked to my colleague and friend Dan Satterberg, and cut and pasted in large part the LEAD program, which is also a component of what we do in Multnomah County. So we have that as a complement. The Treatment First program and LEAD coexist in our jurisdiction. Now, what were some of the motivators relative to why we needed to do the overhaul, or were motivated to work hard on the overhaul of what we had been working with for then decades? One of the areas was and I labeled them original considerations. So one of those areas is we have studied using data and analysis to look at crime categories relative to racial disparities. And in the area, and several things are fascinating as it relates to what you see when you begin to study data and just understand it from that standpoint. One of the troubling things that you'll see is racial disproportionalities will jump out in many areas, and specifically in this area, who it was that was contacted, arrested, taken to jail, and cases referred to my office for prosecution in the area of what we call possession of a controlled substance. I'm going to use the acronym PCS. That's our version of felony drug possession user amounts. So we saw, by looking at the data, I saw high disproportionality relative to cocaine, methamphetamine, and heroin and opioids. Long ago, we moved away from marijuana prosecution, and as you probably know, marijuana, recreational marijuana, of course, and medical marijuana are legal in the state of Oregon and have been now for years. So when I'm talking about this program, largely, I'm really not talking about marijuana, but instead the other three major drugs and a few others. So we had a motivation to make positive changes relative to disproportionality. Wanted to make positive changes relative to addressing collateral consequences of a criminal justice prosecution. And then thirdly, and again, overly summarizing, but thirdly, emphasis on personalized treatment or dosage relative to individuals struggling with abuse and addiction. So three big picture motivations. And so we developed two programs, the pre-adjudication Treatment First program, and then the pre-booking diversion program, LEAD, which you've heard some about, but I'll get more detailed as we go. In the neighborhood of, just from a volume standpoint, we're talking about 12 to 1,800 cases for us per year in Multnomah County. Here is a visual, just to get a concept of what it is I'm going to be moving into. The Treatment First program, it begins just from a very fundamental standpoint with law enforcement. As you can see, we have an offshoot over to LEAD, which I'll circle back around and spend some time talking about. But relative to the Treatment First proper, you're going to look at that PCS arrest. Now, I put a schematic up here, and of course, I know you can't see it, but we're big on schematics in Multnomah County, so I just felt I had to have that up there. But also to include, these are highly thought out. We spent a ton of time. And when I'm talking about we, The defense bar, there was, we had a panel to talk about the intersection of prosecutors with defense counsel. And I'll just say that it is absolutely critical for our program and our community's success in this area to have a strong working relationship with our defense bar. They were brought in early in this program and early in the other program I'm going to talk they were a partner largely. It wouldn't work. And as I begin to talk about some of the dynamics of what we put together, it'll start to maybe suss out why I say that. But relative to that PCS arrest and the post-adjudicate or post-arraignment and insertion into the criminal justice system, we're going to talk about an assessment and report that is done, that is generated and provided to the parties. And then I'm going to fully explain these, what does LN-LN, right, mean, and so on. Well, in summary, low risk, low needs, high risk, high needs, and everything in between. And we're going to spend some more time talking about that. And then ultimately a concept surrounding dismissal and or reduction. But again, I want to talk more about that here in a moment. All right, so risk needs model. So the idea of the old stop court, our original iteration of a drug court was premised on a bit of a, I'm going to overly summarize, a one-size-fits-all response to drug abuse or addiction. Or sometimes even, well, even it could be a low-risk, low-needs individual. And what I'm talking about is contrasting this notion between a, say, 20-year heroin addict who is houseless and sleeps under the bridge and has just been intravenous insertion of heroin into their system for a couple decades. And I'm contrasting that with, say, I don't know, 22-year-old recently graduated from college and had quite a party on a weekend, but it's not part of their daily life to consume controlled substances. And what is the response? Should it be an equal response relative to services and treatment that are provided? I think it's easy for us to say, no, those are two different dynamics. And so this program that we've put together is premised on understanding the risk and the needs of the individual. And so we took a page out of, we spent some time meeting, I don't know if you folks know Doug Marlowe, but he helped us to frame some of this thinking some years ago that looks at criminogenic needs on the left and prognostic risk across top, and what you're really looking at. And we administer the LSCMI, and I'll spend more time talking about that in a moment, in order to help us suss out who is it that is both high risk to recidivate and also has high needs in order to address the risk that exists, as contrasted all the way down to low risk, low needs. So we framed up a program that began to kind of use that model to understand better how to work more specifically than ever before with the individualized needs of the people struggling with abuse and addiction. So we spent a lot of time doing our, call it the research, and we rolled out the program April of 2017, the Treatment First program. LEAD we rolled out in March of 2017. From a volume standpoint, the Treatment First addresses many, many more, just volume-wise. It's a much larger system, took some more time to put together. In summary way, it applies to all the Multnomah County District Attorney's possession of controlled substance issued cases. All PCS cases fall into this category, and again, from a volume standpoint, you're north of 1,000, somewhere between 1,000 and 1,500. Setting aside the LEAD program is why those numbers changed on you. We have two tiers. Tier 1, which is reduced at issuing to a misdemeanor, and that's about 90% of the volume of what we're talking about. So I think I said it, but maybe I said it pretty quick. What we were talking about at the time we put this program together was these crimes, these arrests were for felony PCS. And so I met with leadership from many, many different areas, specifically, of course, to include the sheriff and the chiefs of police of major law enforcement agencies in my jurisdiction. And I said early on, as part of the research part of things, said, here's an idea I want to do and here's why. Are you supportive? Hey, short answer is they had a couple questions, but it didn't take but a few minutes, and it was, yeah, we're in. Let's do this. Let's treat these felonies as misdemeanors as long as, right? And we have a program that we're talking about. We do have about 10% from a volume standpoint. We believed at the time we were putting this together that would still be issued as felonies, but we would be reducing them to misdemeanors following participation in the program. We assess, in most instances, nearly everyone before the first trial date. And I'm going to talk more about that assessment as we drill down further. And then the assessment, following that, a report is generated that is supplied to the parties. And it recommends, or it outlines, if you will, tailored treatment and supervision, and looks primarily at those risks and needs. We have the opportunity for dismissal or reduction, and opportunity for early supervision termination. So we're both trying to provide specific dosage and response to individuals, but simultaneously a degree of incentivizing them, of course. So another early part of this was putting down on paper some of the mission and purpose. The notion of saying some of our motivations, remember I had those original premise, racial disproportionality, reduction of collateral consequences, better treatment. That was important. It was important to me, and it was important to message to prosecutors in my office, public safety partners, and also the broader community. Why are we doing what we're doing, and why are we overhauling a system that had been in place and was a Cadillac program for decades? One of the things that I made sure that was first true, and made sure that we prominently spelled out as far as the early mission and purpose, was a recognition that we're very aware of the significant disproportionate number of persons of color who were arrested and referred to and inserted into the criminal justice system for these PCS offenses. We endeavored to reduce the negative impact of criminal justice involvement and its associated collateral consequences, and embrace a treatment-first philosophy. Other areas of what we talk about is physically, mentally, I guess, but sometimes physically backing up from the punitive response to addressing abuse and addiction to controlled substances, backing up away, us, law enforcement, and creating space for services and treatment providers to fill in that in between us and the individual that we're talking about. And so that's in part why the program was titled what it was, Treatment First. And that's both, philosophical and physical, kind of actual as a practical matter at times. We developed as that report, if you were to continue to read the hard copy of our policies and protocols, you would see some core principles. We talk about the Treatment First team, and this is, again, a recognition, a spelling out, but also a recognition that this is a system-based response. This is a program that, while we put it together quite literally at my desk table in my office, with the original iterations were with prosecutors from my office and a lot of brainstorming, we quickly needed to branch out and embrace the assistance of everybody else in the community and our public safety partners. We say that we want to have, despite the nature of the adversarial process that we all work in and that I've been a prosecutor for now 30 years, and worked in, we say we want this to be non-adversarial. We want this to be closer to a partnership. Does it always work out that way? No, not always. There's still a place for the adversarial nature at times. As was talked about earlier in one of the panels, we in Treatment First, there still is a charging instrument, and the individual is presumed innocent unless or until proven guilty. We need to recognize the value of that premise, but we want to quickly move toward, can we come up with a resolution that's appropriate, understanding that some people may be incorrectly charged, inappropriately charged. So we do still have process, but we're moving things up and working a lot harder to identify early and promptly what the needs are of the individual. The assessment for substance use disorders and other treatment needs shall be conducted by appropriately trained and qualified professional staff familiar with harm reduction philosophy and risk and needs assessment tools. And so we have that, and I'll spend more time here in a moment drilling down into that. I have referred different times to dosage, and so when I talk about dosage, that dosage, for example, the low-risk, low-needs individual is going to be put on probation for 6 months. they're going to be checking in with a very light touch with a probation-based officer, but largely we're not doing much with them. The low risk, low needs. Generally speaking, that is a category that from a recidivism standpoint, you don't have to spend your valuable resources on. So simply put, don't. There are exceptions to everything I say, so you got to be aware of the exceptions. Look for the exceptions, but generally speaking, save those valuable resources for, and I'll contrast it, the high risk, high needs, and I'll show you a schematic about that here in a little bit. But we say out loud that we emphasize treatment over punitive sanctions. We recognize that there is a role for personal and social responsibility, accountability, and public safety. We recognize all those things, but they all can work together and they actually can coexist, and I think in a robust, helpful way. So back to that report, because this is where the relationship, and I'm going to use the word trust, with Defense Bar has paid enormous dividends to, I think, our community over the years. And this program, and the one I'll talk about here in a little bit, the MCJRP program, reflects that. Because this report, the concept of this report is, and I'm going to be kind of summary and quick talking about it, it's post-arraignment, while pending trial, and with counsel. Defense counsel and their client are agreeing to engage in a static and dynamic question and answer, risk and needs assessment, and some other information that details what it is that they need to help, what services they could benefit from relative to us helping them with their abuse and addiction, which then transcends into a reduction of recidivism. And so we use the LSCMI, the Level of Service Case Management Inventory, or for women, we use the WARNA, Women's Risk Needs Assessment. For the female population, as I note, we further drill down at times with the TCU drug screen in order to understand needs better as we walk through this. The report that is generated, I've just given you a snapshot. These next two pictures, well, I should spend a moment on this one actually. The report is, I'm going to go forward and then back. We are given this, and I say we, the defense counsel, the judge, and my prosecutors are given this document pending trial. Now, originally, when we came up with this concept, there was a lot of understandable just kind of hesitation from the defense bar. Wait, first, are you kidding me? You want me to have my client be interviewed by a government employed individual, right? For us, it's parole and probation does this report assessment. And what if he says, because the premise is you've charged him with possession of heroin and you're going to ask him, are you a heroin addict? Again, I'm being overly simple. But that's going to populate aspects of this report. And the answer is, yeah, we do want to, and here's why. And so in order to have this be valuable and move forward, because the premise is we are much more informed, more so informed than ever before as we reach dispositional decisions. But going back, some of that in the top end, you see some codes and citations of ORSs and such. What we're doing is we're saying in every way possible that this report will not be released, and here's the word trust comes in, it will not be misused. The premise was, the concern was that this report would be used to help prove their guilt, right? Or to harm them in some way relative to a release hearing or in any number of other ways. And in an overly simplistic way, I said, I promise that we will not misuse this information. And I can proudly say that that promise was made several years ago now, and we have not had one instance, I have not had one phone call of a defense counsel saying that one of my prosecutors has misused that information. So that's where trust truly and relationships truly matters, because but for this report, we wouldn't be as good at what we're doing now. Relative to back to what we see as far as part of these reports, when you drill down into this information, this is just a table to give you a flavor of what we saw from a number standpoint. So in the upper left-hand quadrant there, you see the high risk, high needs. The most intensive resources we have are dedicated to that group because they will, from a statistical standpoint, are likely to recidivate at the highest rate and need the most attention relative to services. That is that, at times, in my overly summary way, that individual who struggled with heroin addiction for 20 years, intravenous use, and finds himself houseless at the time. So what can we do? We want to identify that person and then respond appropriately. And as you can see, 52%, as we began to break these out over time and study what we're seeing, 52% of the individuals in the Treatment First program as of September 12th, just close to a year and a half into the program, are high risk, high needs, as contrasted with low risk, low needs, 17%. Here's a thing that also jumped out to us. It was a concern of mine, but I said, despite this concern, we're going to do it this way anyway, and I got my partners to do it, agree. And that is, we're going to find pretty quickly that today's services, today's resources that we have available to meet the needs of the population that we're working with are inadequate. I believed that we would, but instinctively, essentially, again, I'm overly summarizing, I said, we will never be properly resourced if we don't tell our funders and the people that fund our offices and fund our services if we don't tell them of the needs we have. So let's do this. It's going to create additional tensions down the road. I gave this presentation, or at least a version of this, to the legislature here about a month ago in Oregon and to our local Public Safety Coordinating Council in Multnomah County. I wrapped up each of those two sessions with saying, the way for this program to not succeed is if you don't properly fund the services side and some of the infrastructure to this. And that is reflected in that high risk, high needs. These are folks who need our help to walk and weave and get themselves through struggles with abuse and addiction. Some months after we rolled out our program, so in August of 2017, Oregon adopted a House Bill 2355. That House bill had many components, but woven into those components was they followed our lead, that's a pun, they followed our lead relative to moving toward misdemeanor prosecutions for what used to be felony. Only what they did is, and should be applauded for it, but it doesn't go as far as our program. And this is where, because here in a bit we're going to look at some data, and it's going to kind of paint a picture for you about what the differences are. So relative to the Oregon House Bills 2355, which I remark there took effect August of 2017. So just remember that's about 5 months after we began. And it also had some components that are different. And I walk through these. I won't drill down, but I'll point them out, the difference between our program and the state statute, and that'll help to clarify some of the data here that we're going to see in a minute. That data was, one of the components of 2355 was for the Oregon Criminal Justice Commission, a think tank organization, if you will, located in Salem. They were commissioned pursuant to that statute to study the impacts of House Bill 2355. So they wrote a report. As you can see, it's a little bit hot off the press, a little bit now, I guess, it's a couple months old, but it's relatively recent, and they studied the first, couple of years, if you will. They reached back and studied our program dating back to its infancy, so April, and added it into their study. And they were studying several things that, I'll just get all this up, at once. So they studied several things. I'll start from big picture. They looked at the state of Oregon, and they saw some things that confused or surprised them, but it was PCS arrests. And I'm going to contrast that with convictions in a moment. But as you can see, what they saw following the implementation of House Bill 2355 is a reduction from a state standpoint in these PCS arrests. Now, why the reduction? And there's a lot of people, we're trying to figure that out. One of the variables is this is about the same time the fentanyl scare was coming around for all of us relative to law enforcement. This notion of touching what is believed to be controlled substances. And I think that had it did have an effect. How much of an effect is unknown, right? What's another potential effect? The notion of NIC testing and the kind of controversy or reduction in use at times with different jurisdictions. We have 36 counties, as I mentioned a little bit ago, and we have, I don't know what it is, probably 100 different law enforcement agencies, and so different responses surrounding this, all of which are coming at the same time. Together with, it's an undeniable premise, at least, or variable that we're trying to further understand is, well, does it matter to law enforcement that you move from felony to misdemeanor? Do you emphasize it less from a where do you deploy your resources, says, Captain so-and-so or Chief so-and-so? And I recognize, I believe that is a variable somewhere. So the combination of these things help us to see, at least from a state of Oregon standpoint, a drop. Not surprisingly, that drop then translates into a drop in PCS convictions. This is a combination, state of Oregon, of felony and misdemeanor. So, of course, one would beget the other, generally speaking. When I use the term, and when this study, and as you can see, the slides are different because I got permission, I literally used their slides from the CJC Commission. But when they use the term conviction, that includes those that are later dismissed following some form of participation in a drug treatment court. So just to say that, it is that initial entry of a plea or a finding by a court. So you see a reduction, again, not surprisingly. So now we look at this, the difference between felony and misdemeanor convictions. I'm going to, one more slide there. So the orange color is going to be your misdemeanor convictions, and the other color is your felony convictions. And as you can see, you see the orange begin to be prominent. This is, again, a statewide lens, prominent in the 2016-17. Remember, that law became effective August of 17, and it really takes place in the year, in the last 12 months or so. And so you see a significant increase of misdemeanor convictions relative to felony. Here's where the Multnomah County Prosecutor's Office's program begins to really look different. So on the left-hand side, we've switched colors a little bit, but on the left-hand side, you see a breakdown of, let me go back. You see a breakdown of the state and broken down by race. And in the right-hand side, Multnomah County, likewise, broken down by race and misdemeanor versus felony. So on the left-hand side, in an overly summary way, you have, I think the percentage is 27% of the statewide prosecution numbers were preceded with misdemeanors following House Bill 2355, leaving the balance 73% as felonies. You also see a articulable and statistically significant difference relative to, and it's bullet point 3, where it reads, when examined in this way, statewide black race received misdemeanor treatment, it should say, less often than whites, but about equal to whites in Multnomah County. So you're beginning to see what we then saw, and as the next few slides start to tease out, beginning to see some of the implications of a policy change that we made that the state did not, and what effect that seems to have so far. So again, on the left-hand side, 27, I'm going to round it, well, we'll just 27% is misdemeanors, the balance is felonies. On the right-hand side, that's 90% as misdemeanors, 10% as felonies. And as noted, the race relative to that disproportionality is much more balanced and equaled out. They, being the Criminal Justice Commission, then used raw differential representation, RDR, in order to drill down even further into disproportionality. They use the definition of RDR here that they used. They're using essentially whites as a baseline and then looking at other races as they are prosecuted more or less relative to race. That's an oversimplification of what you're just reading. But here's what we begin to see. From a state standpoint, we see a dramatic reduction in disproportionality. This is state combining or including Multnomah County. From a perspective standpoint, our office, my jurisdiction, makes up about 20% of the overall state data, criminal justice data, relative population and such. It just is about 20% almost always. But you can see right away the dramatic difference in PCS felony convictions relative to disproportionality. I'm going to move on to Multnomah County. So Multnomah County went from high disproportionality. Again, that baseline, the dotted line there, is the Caucasian based line. Everything above or below, if you're above, it's disproportionality in an overrepresentation. Below is less frequent. And so when you look at the bar graphs relative to black, for example, I'm colorblind, so I'm going to call that orange. But you see that this is reflecting what my office and I saw was high disproportionality in this crime category, and we endeavored to do something about it. And so we're just pleased and proud that we have done something about it. We've driven down the disproportionality as it relates to really everyone. You see those lines are nearly merged for all races relative to fairness and equity relative to felony criminal prosecutions and convictions. This is another graph that helps. It's just in a way, it's a different form. Some people prefer one form of looking at a graph versus other. This is a similar graph. It's really almost saying the same thing, but the words that are used, a significant drop in felony convictions overall, but also this recognition of reduction in disproportionality as it relates to race. So what we've done now, so going back to those three original considerations that I had when we put together Treatment First, we looked at reducing disproportionality, and so far the evidence is telling us by an individual or independent analysis, the Criminal Justice Commission of Oregon, it's telling us that the state is doing better than ever before, and Multnomah County seems to be doing quite well in that area. Very, very proud of those reductions. We need to continue in many, many areas, continue that effort. The other was, remember, it was reduce collateral consequences. There are a tremendous number of collateral consequences associated with a felony conviction. And so we also wanted to, this notion of stepping back and creating space. So there's lots of different reasons for doing what we're doing and having a robust kind of entry into the program. And we accomplished our early kind of thought about, this is going to be about 90% of our cases as contrasted with the state, which as we saw was 27%. Here are some things that we don't know yet that we're keeping an eye on. The program is early enough along that we don't know what recidivism looks like. Because some of it we've talked about earlier, what is success, right, in criminal justice period, what's success look like in this program? And Oregon has, and one of those markers classically is recidivism. Oregon has a definition not unlike many, and I dare say most of you, 3 years, any arrest or conviction for misdemeanor or felony within 3 years. And so we don't know yet because the program's too early in order to answer that question. Early anecdotal returns are, it's not going the other way. In fact, we think we're just fine, but again, we're not going to be able to know. I probably shouldn't even have said what I just said because I don't know yet. We're just going to need to have the data tell us. One of the concerns surrounding House Bill 2355 and my policy adjustment was people aren't going to participate. You know, drug courts are going to go away. And simply put, that's just not happening. One of our challenges to be self-critical of our own program because of the non-punitive kind of aspect of this and the true desire not to use custody as kind of as strong of a stick or an incentive. We are challenged with failure to appear rate, having participants kind of work through the program with us. What I don't want to do is ask a judge for a warrant for this person that we're trying to give services to. We've gone backwards. So we're struggling with that portion of things, interested, to kind of help us get that right if people have other good ideas over time. We're working on a lot of different ones. And this notion by some, colleagues and skeptics of, well, we're going to see increased drug use relative to this type of program. And simply put, the answer is we're not seeing that, at least not yet, for sure. We are just not seeing it. So right now, the program has so far attained each of the goals that we set out to do, minus the one, because remember, public safety matters here. But I think that when we are properly addressing through appropriate dosage and treatment and services to those who need it the most, high risk, high needs, and we are giving light touches appropriately to those that are low risk, low needs, then we're going to have better outcomes. Different studies over the years have told us that is the direction to go, and we seem to be on that path. So I am optimistic, and I suppose I'm going to say confident, that when the recidivism data and those success stories really are able, we can articulate them more than just individual storytelling right now, we're going to see that this has been a success. Now, I'm not going to spend a lot of time talking about LEAD because all of you probably know a fair amount about it. I wish Dan was here. His jurisdiction was the genesis of this. As I mentioned earlier, we began, but it's worth noting because it's part of our response. There are some, it should be said, so I'll say it here, there are some people who respond well to a brick and mortar abstinence-based response model. Some individuals struggling with abuse and addiction do, and some respond better to a harm reduction model. And there is a place for both. And even if you have an abstinence-based model, it still should embrace some harm reduction philosophies. There's a place to coexist. We have two programs. The LEAD program we still call pilot. We have expanded. It's been so successful here since we began in March of 17. We expanded geographically here a few months ago, in part because law enforcement officers from our jurisdiction, the geographic area is the city of Portland downtown core area. So city Portland police officers were encouraging us to expand geographically. They love having this LEAD harm reduction philosophy tool in their tool belt to help people that struggle with this, with abuse and addiction. As you know, because I think many of you are familiar, it's pre-booking diversion. It's upstream of the Treatment First program. So it is truly a law enforcement assisted. And so I've given a couple of bullet points over that. Once again, an emphasis of community buy-in and support. This is just a photograph of when we announced the rollout of LEAD program. At the podium there is our county chair, a true champion of the LEAD program. Again, you need champions because you need both philosophical, but also at the end of the day, some resources because to the tune of about $750,000 was invested right out of the gate in order to fund case managers and those individuals working with people struggling with these needs. I touched on, I think, but I'll just hit it again real quick. Right now, I think Dan's program, last time I checked with him, tends to run at about a 300 participant number. We're at 150 and still growing at this point, as contrasted with the Treatment First. Again, just from a numbers standpoint, that's the big volume. That's in the neighborhood of that 1,200 or so in a calendar year. So LEAD is more modest. but it is a tremendous complement to kind of our array of responses. Now, this is where I'm going to transition and talk some about the first generation of justice reinvestment, right? So the treatment first, the concepts, many of them that we implemented in treatment first, they began with this program that I'm going to spend some time on. So first, kind of a revisiting of Oregon House Bill 3195, or 3194. Essentially what it was trying to do, set out to do, the JRI concept in an overly summary way, was sentencing and other law changes to help safely reduce the use of prison beds and their associated costs, right? August 2013. What should it accomplish in some ways? Some of these premises at the statewide level that we talked about is it's going to flatline prison growth for about 5 years, which it has. Prevent new prison construction for at least a decade, which it has and appears to do into the future, because we do prison forecasting like no doubt all of you do. I'm going to use a term because it's used commonly, the avoided cost savings, sometimes avoided costs. So it's this premise of what didn't you have to spend? That is woven into the JRI concept. And so when we passed 3194 and implemented it, right out of the gate, the avoided cost assessment was $19 million, which was made available to local communities to then, in a grant-based, again, Criminal Justice Commission monitors this, the grant that is allocated by the legislature, dispersed to local communities on a formula basis in its infancy. The last two biennia, so we're in a biennium that ends June 30th of next year, Oregon is. We're operating under a notion that we avoided, the cost avoided in the biennium that we're in right now was $53 million to Oregon. And the biennium before was also $53 million. Each of those two biennium, the legislature, following a lot of arm wrestling, but the legislature authorized $40 million, I'm rounding it, in each of those 2 years to be dispersed to local communities. So when you add these up, right now, following the passage of that bill, in the neighborhood, again I'm rounding, $100 million has been reinvested into local jurisdictions in order to help accomplish the stated goal in premise number one. We also wove into this allocation that of the $100 million over the period of time that I've just summarized, 10% off the top is to be allocated by local communities to nonprofit victim-based services. And then the balance is really up to local communities to allocate into obtaining kind of stated goal number one, so to speak. So what did we do with our then allocation? Well, we began meeting in anticipation of this type of legislation. We began as a local community meeting, and we joke about it now, it's turned into a bit of a cult-like scenario. We meet every Friday morning at 7 a.m. for an hour and a half. Now, I said every morning. It began in almost the end of 2012. And I say every Friday morning, so that's an exaggeration. But I will say it's nearly every Friday morning. They're meeting tomorrow. I'll be here, but they're meeting tomorrow at 7 a.m. as a local public safety community, and we get together and we hash out many different issues as it relates primarily to the MCJRP program. The first several months, we're putting together what is, for us, the most complicated and sophisticated and best program the criminal justice system for Multnomah County has ever designed. What are its stated goals? And I've used the acronym MCJRP, because that's Multnomah County Justice Reinvestment Program, and then a dash or a slash JJRP, Juvenile Justice Reinvestment Program, because we've woven in and we moved into a subcategory of adding certain juvenile, what we call in Oregon, ballot measure 11 offenses, I by virtue of policy, wove in the juvenile component of violent crimes, what we call tier 2 violent crimes, into this program. What are our stated goals? Hold offenders accountable, reduce offender recidivism, decrease utilization of Oregon Department of Correction prison beds increase public safety, decrease victimization, increase restitution collection. These are all agreed upon principles. We've got a wealth of documents that spell all this out and lots of 7 a.m. meetings to hash all this out. But how do we do, it's easy to say these things, but how do you do it? Can you do it, and how do you do it? The overarching premise is we're going to be better informed at a critical decision points as we analyze case resolution. So what's that mean? First, we start with, well, what crimes are you talking about? It's almost easier for us to say, what crimes aren't you talking about? Because now we've moved away, just to again remark, moved away from the PCS conversation we were having earlier on, and now what we're talking about are, for Oregon, presumptive prison-bound cases relative to sentencing calculations that exist in Oregon, minus the crimes that are listed. Essentially, they fall into 3 big categories. Homicide, domestic violence, and sexual assaults is what you're seeing as excluded. Everything else is in the program, and that equates to right about 1,000 individuals per calendar year are in the MCJRP program unless they opt out, and only a few per year opt out. So what is the MCJRP program? Well, here is what is, I've never found anybody who likes this acronym. So if anybody here likes it, please let me know, because I came up with it and I don't even like it. But I came up with it. The acronym is PAVRON, but what does it stand for? And those is where I'm actually more pleased with what it stands for, as contrasted with the acronym itself. But I'm going to steal a chapter from what my friend John Chisholm said earlier, and that is, and others, the concept of weaving into professional judgment such things as risk and needs assessment tools. So the P, and if you could see, you can see it a little bit, but this is another schematic for us, one of our documents that we use to help spell out and remind us of our program and its foundations. But everything that I'm going to summarize here informs professional judgment. The A stands for accountability, both personal and social. The V stands for victim input and impact. The R stands for risk assessment. The O is offense information, both mitigation and aggravation. And the N is needs assessment. Spend a little bit of time, I chose to put this up just as really a reminder of many of these variables that we're talking about come as common sense, but some of these variables that we're now using we have never used before. Because once again, well, I should maybe finish a thought here relative to victim input and impact. One of the questions I heard from one of you here with, I think it was maybe the last panel, is where does a victim conversation come into these equations? Because this program is viewed as not a classic diversion, meaning diversion from the criminal justice system or such, but it is viewed as a diversion from prison. And I'm going to give you some statistics to help bear that out here in a few minutes. But we need to recognize the victim voice here. No, they do not make the decision for us, but we listen to them. We find informed victims are almost always in lockstep with us, not by virtue of us pushing them, us being the criminal justice system, but they really, truly, almost always want to be informed and respected. And then they'll understand what it is that we're all talking about. And we get to a common place almost always. Another schematic, this is just going to begin to walk through, and I'm not going to spend any time in the interest of time, walking through a complicated process. That big block that you're looking at is that assessment that's done. So you earlier saw in the treatment first arena that we get pre-adjudication assessments, post-arraignment, with defense counsel's permission and participation by their client. Here's where it all started, the MCJRP program, where we are doing the LSCMI again. That's where that trust came in. We will not misuse this information. We will use it to help promote a conversation relative to what are the needs of your client, and can we provide those needs and safely do that in the community as opposed to in prison. It also has resulted in us having conversations about length of stay if prison turns out to have to be the answer. here are some of the things. I'm not going to read all these, and again, in the interest of time, I think I've just got a couple of minutes, but I think I can do this. But we are looking at everything that we can in order to understand better what this person's about. Plugging that information back into our schematic of next steps. We have a robust judicial settlement conference methodology and involvement. So judges, parole and probation, defense counsel, and prosecutors and victims are all part of the conversation about how to resolve 1,000 times a year a presumptive prison case. We have a wealth of data surrounding this program and its complement to JJRP. Some of the high points, I think this is the last slide, some of the high points deal with, so pre-MCJRP, out of 1,000 people, about 45%, 450, receive probation. Post-MCJRP, now it's about 70% receive probation. When you begin to plug in those numbers, 200 to 250 people per year are not going to prison that used to in Multnomah County. And then you multiply that by, now we're operational, closing in on 5 years. There's been 1,000 people who have not gone to prison as a result of us doing a better job of understanding them and how we as a system can respond. Despite the fact that 70 to 80% score out actuarially, right, on these risk needs as high risk, high needs. It just means we have our work cut out for us. And we have programming that is paid for by that JRI return money to help with that. Recidivism, we measure it from beginning to end. This is a group that we have 3 years of data. The recidivism rate is reduced for this population, despite the fact that 200 to 250 high risk, high needs are added to our probation population, which you would expect would drive up the recidivism on an aggregate data, but despite that addition, our recidivism rates are still lower. The juvenile Tier 2 ballot measure 11, presumptive prison, highly controversial kind of group relative to juveniles being treated as adults, and some are in Oregon. 30% used to receive probation. Now with this program in place, 82% receive probation. I think that's it. Did I leave any room for questions? I'll bet I didn't. No. All right, good. Then I'm off the hook. All right, thank you.